Acting Deputy President. At the outset, I want to make it clear that I support the measures in this bill, but I don't believe they go far enough. And I think an analogy, perhaps a crude analogy, is to say it's a bit like a patient who is seriously ill. They need 200 milligrams of an antibiotic to make sure they get better, but here there is only 50 milligrams are being given. So it might help a little, but it won't solve the long-term problems. But I do acknowledge the work of the Minister's office, of Minister Clare, of his staff, of Mr Quadrio in particular, his departmental officers for the time they spent discussing these issues with me, and it was a genuinely good consultation in relation to that. Now, I've spoken in this place before about the importance of supporting Australian businesses against dumping. I acknowledge that the government has made improvements, real improvements to Australia's anti-dumping and countervailing system, but there is still much more to be done. Now, I note that this bill is time-limited, so I will keep my remarks brief, but I want to put this in perspective. Dumping is effectively where goods are being sold, sent to this country at a cost below their market cost in their home country. In other words, they're literally being dumped, and that costs jobs. It costs opportunities, it destroys Australian manufacturing, and it's completely unfair. And the WTO rules say that dumping is not allowed. Now, my concern is that we take such a literal interpretation about the WTO rules that no other country does. And I was struck by a conversation I had by Michael O'Connor, the National Secretary of the CMFEU, who I think does have a genuine concern about jobs and manufacturing in this country. And what Michael O'Connor said to me a year or two ago, which is stuck in my mind, was that he was at a conference in Sweden talking about the timber industry, about trade issues, about jobs, and when he said he was from Australia, some of the other delegates from Scandinavia laughed at him and said, "Australia, we regard you as the free trade Taliban because you take such a literalist, fundamentalist approach to the WTO rules that no other country does." And I'll give you an example. Solar panels are being dumped in the United States, or they were being dumped, and in Europe. The United States and Europe are acting against China in relation to those dumped solar panels. What do? We have just about one remaining solar manufacturer in this country, Tindo Solar, in Adelaide. I note the Prime Minister was there a few months ago to open up their facility, but they are operating at something like 10% of their capacity because they have to compete with dumped products from overseas. And my fear is that because Europe and the United States are putting up countervailing duties, or rather duties in relation to dealing with the dumping from China, where are we going to end up with those dumped panels? They'll end up here in Australia because we seem to have an approach to date that has been completely unsatisfactory. So I do want to acknowledge the work that Minister Clare has done on this, and the Minister before him, Minister O'Connor. But I think we need to be more flexible and creative in the way we approach these cases so that we comply with WTO rulings but still put our own industries first. We should have free trade, we should have fair trade, free trade, but it shouldn't be free-for-all trade. And that free-for-all approach is putting our manufacturers and industries under ever-increasing pressure. We're coupled with an artificially strong Australian dollar, and it's still too strong compared to what it ought to be, according to many commentators. Our manufacturers are struggling, and when you look at the level of quantitative easing in the United States, and that's being Mr Bernanke is backing away from that, but that's affected the value of their dollar previously. We know in the United States there's been a massive stimulus and quantitative easing package where the yen is lower than it ought to be. It's been artificially manipulated, some would say. And as far as the China's currency, the renminbi, it's even worse. It's fixed by the government. There isn't a level playing field when it comes to issues of currency. Now, the Prime Minister's Task Force on Manufacturing released a report in August last year that estimated that 950,000 people were employed in manufacturing and stated that it contributes 8% of GDP directly. Now, that doesn't include the significant amount it contributes directly through flow-on effects to businesses. But as I've also stated, over the last 4 years, over 100,000 jobs have disappeared from the sector, and that is a conservative estimate, Mr Acting Deputy President. The report also estimates that another 85,600 jobs at a minimum may be lost in the next 5 years. that's something like close to 200,000 Australian families that will lose their jobs in manufacturing, and and that includes food processing. I see that Senator Colbeck made reference to that earlier, and we're facing a situation where the last remaining frozen food facility in Australia might be closing down in the next 3 to 5 years. So if you're going to buy any frozen vegetables in this country, they'll be coming from overseas. How can we do that with a country? How can we allow that to happen in a country that is so abundant in its food production capacity, that it has one of the world's best reputations in terms of clean, green produce, yet we are looking at losing that facility? Now, between 2008 and 2010, capital expenditure by the manufacturing industry decreased by 20%, or $4.1 billion. There has been a 55% drop in furniture manufacturing, for example, plus a 43% drop in printing and a 10% drop in machinery and equipment manufacturing. Our mining boom has meant we've taken our eye off the ball when it's come to manufacturing. We've also forgotten that without a manufacturing industry, we lose something that is incredibly valuable. We lose something as a nation that cannot be replaced. We lose those skills. We lose the ability to make things ourselves. We lose the ability to export to other countries. We lose innovation, and that is a key issue. That's one of the reasons why our car manufacturing industry is so important in this country. To the Holden workers that are listening, who work at Elizabeth in South Australia, I understand, and many others here understand, the importance of your industry. Now, for each of the major manufacturers that are at risk, there are smaller component manufacturers that depend on them for a living. The multiplier effect, the economic impact and string of job losses linked to these major manufacturers is huge, and it's estimated that Holden's is lost from South Australia. That would mean something like 16,000 jobs would be lost, and I dread to think what that would do to the northern suburbs of Adelaide. I don't want the northern suburbs of Adelaide to be turned into some sort of industrial wasteland. We must fight against that. We must do everything possible from a sensible policy point of view to make sure that doesn't happen. But even further than that, if we lose our manufacturing capability, we lose our independence, something that I know that Senator Madigan has been very passionate of, and I've been very privileged to be part of the Australian Manufacturing and Farming program that he has instigated, that he has led. We can already see some sectors where skill shortages have led employers to bring in overseas workers on 457 visas, but we don't seem to be doing anything to address those shortages, why they happen in the first place in terms of skills and education and basic training. Protecting Australian industry is about more than protecting the big car manufacturers, which is very important. It's about protecting our skills and our future, and I'll be moving a number of amendments to this bill. And because this debate is time-limited, and for those out there listening, this is not a good way to run for the Senate to operate as a genuine House of Review, to have bill after bill after bill being time-limited in terms of a guillotine. And if I'm ever in a position to deal with this, I agree with what Senator Madigan has said previously in this place. If I'm ever in a position where my vote may count as to whether there's a guillotine, well, I can tell people on both sides of the chamber, you can forget about it. If you want to sit here on Saturdays, Sundays, week after week until we sort out the legislation, then so be it. And I think that Senator Madigan is of the same view, and he's just indicating that as well. So I'll be moving some amendments to this bill. I'll be speaking to them, and I think that I do need to acknowledge that there is an improvement in the system. We have a situation where, for instance, a company like Tindo Solar, who was quoted $1 million with 18 employees to run an anti-dumping case, at least now, through the government's initiative, that there is a mechanism, a support system, an advocate that they can go to who's very well regarded in the industry, and I do commend the government for that, genuinely, because that is an improvement, because those small manufacturers like Tindo Solar would not have had a chance in hell to be able to at least even look at a case in relation to that. So that is a clear improvement, and Minister Clare and his office and Minister O'Connor before him deserve to be credited for it. But this bill does not address some fundamental issues which the amendments that I'll be discussing shortly. And if I may obtain your guidance, Mr Acting Deputy President, I have some amendments on file, but because of the time limits involved, Senator Madigan has indicated that he wishes to co-sponsor these amendments with me, and I'm very pleased for him to be able to do that. I'm not sure whether I seek leave from you, from the chair, I can add Senator Madigan's name to these amendments.
Senator Xenophon, an indication as you've made is enough. So we'll
That's
take
fine,
that
and I'm grateful for that. I'm grateful for Senator Madigan's support in co-sponsoring these amendments. The first lot of amendments relates to the second reading amendment. For those out there who are listening intently, the issue is this. A second reading amendment does not bind the government of the day. It is not in the legislation itself, but what it does is that it sets a clear statement from the Senate to ask for something to be done. And what I'm asking to be done in relation to these second reading amendments, jointly moved with Senator Madigan, is to call on the government to commission an independent review into several issues regarding the anti-dumping system. Firstly, the review should consider the current provisions relating to particular market situations, and I put that in quotes because that's a specific term of art in relation to the legislation, and whether they are sufficient in outlining the circumstances where a market is not suitable in determining a normal value of a product. And a normal value, as defined, is the expected retail value of a product in its domestic market, which forms an integral part of an anti-dumping case. However, some markets do not operate on the same commercial terms as Australia, and that is something we need to consider. Just last night, Mr Acting Deputy President, there was the Four Corners story about the disaster in Bangladesh, about the clothing industry there, that the recent tragedy in Bangladesh where over 1,120 people were killed when a factory collapsed. A further 2,500 people were injured. We've heard countless terrible stories of child labour, of people paid tiny sums of money to work excessive hours, of workers locked in buildings and subject to unimaginable conditions. We've also heard stories of rainforests cleared and cheap timber dumped on the Australian market with huge environmental impacts, and I wonder, Mr Acting Deputy President, whether the over 200 jobs that were lost at the Kimberley-Clark factory in the southeast of South Australia, to what extent were dumped products responsible for that? They clearly were, and whether any of those timber products, those paper products from rainforest timber, because the controls, the quality, the safeguards that are here in terms of Australian manufactured products just don't exist in some other countries. Now, these circumstances, whether it's child labour, whether it's rainforest timber, whether it's virtual slave labour, these circumstances need to be considered when determining the so-called normal value of a product. Secondly, the review will also consider the application process, including the impacts on small businesses and the burden of proof that applicants carry. And I plead with the opposition, given the statements of Sophie Mirabella, the Shadow Minister, in relation to this, to seriously consider that. It's not forcing a change of the law, but it's requesting rather a review of something as fundamental as this. In jurisdictions such as the European Union, the process is more supportive for applicants, particularly small businesses, with officials providing a higher level of guidance in terms of information required. Thirdly, the review will consider possible amendments to the way export price is determined, similar to my previous amendment, I moved with Senator Madigan. The terms of reference for this review will be determined by the Trade Remedies Forum, and the review itself will be undertaken by an independent party. This amendment also states that the review should be undertaken within 12 months of the commencement of this bill and the report tabled in both Houses of Parliament. The issues outlined in this review are ones that need urgent consideration. Changes in this area will make significant changes for Australian businesses and will further improve our anti-dumping and countervailing systems. And it's a second reading review. It's a second reading amendment. It's about at least getting this process to improve on the existing amendments that have been in place. The fifth or sixth tranche of amendments that we've seen, this will go that step further to deal with issues that directly impact on small businesses in this nation. I also have a number of amendments that I'm moving jointly with my colleague Senator Madigan. Item 1 inserts a new item into subsection 269 TAB1, which relates to the determination of export prices of goods exported into Australia. Determining the export price plays an important role in determining whether goods have been dumped into Australia. This particular amendment broadens the criteria to include the circumstances when an importer sells goods in Australia on less than profitable terms. This relates to when an importer is selling items at a price if they were manufactured on a similar basis as like Australian products, they could not be retailing at a profit. For example, if an Australian manufacturer knows that their product usually costs $2 to make in Australia and an average of $1.80 globally, but an importer is selling the item in Australia for $1. By reverse engineering these figures, it is clear that the importer is selling goods below cost or dumping them into Australia. This amendment will give Australian manufacturers more flexibility when they are mounting dumping cases and recognises an issue that is currently not addressed in the Act. Another amendment, the second amendment. The aim of this amendment is to make more import information available to Australian companies for the purpose of anti-dumping cases. I note the Australian Greens have a similar amendment, which I support, and I commend them for moving it. This amendment is much broader and allows for the type of published information to be determined in the regulations. So that's and I note the government's concerns in relation to the amount of detail specified in the Greens amendment. So I intend this amendment to be a compromise between the two, although I'm very happy to support the Greens amendments, and I understand that Senator Madigan is as well. The third amendment, item 3, the purpose of this amendment is to require the Trade Remedies Forum to undertake a review of the anti-dumping provisions in the Act. The aim of this is to ensure the government's reforms are operating effectively and to highlight any areas in need of further reform. It also states that the Minister must table a copy of the report when completed. The fourth item. The aim of this amendment is to reverse the onus of proof in the Act. Currently, Australian manufacturers must bear the onus of proof in dumping cases. That is, they must prove that dumping exists, this amendment places the onus of proof on exporters so that when a complaint is made against them, they must prove the complaint to be false. I believe it emphasises the need for Australia to be more flexible and creative about our approach to the WTO and to trade in general, so we're not the free market Taliban that we are laughed about in other parts of the world. I note previously that the opposition has stated that they would support a reverse onus of proof, and I refer to an opinion piece that Shadow Minister Sophie Mirabella wrote on the 14th of November 2011 in The Australian, where she said, the coalition policy will also provide Australian authorities with a greater opportunity to make use of preliminary affirmative determinations. For 2 months into an investigation, these PADs create a shift on the balance of an investigation, requiring the foreign producer rather than the Australian company that believes it has been damaged by the dumping to prove its conduct hasn't hurt the Australian industry. I'm just asking the coalition to support the Fifth Amendment, rather, which is directly modelled on what the coalition has said. My plea to this chamber is that we need to do more for Australian manufacturing. This is not about protectionism, it's about fairness. It's about Australia not being treated as mugs by the rest of the world when we're dealing with dumping cases. That's why these reforms are essential.